tossed out of an estate sale and told they could be discriminated against for any reason. 2 self-represented litigants take that insult to federal court. Dismissed? Yes, but not for long. Stay tuned for a story where pro se persistence earns a second chance at justice. Hi, I'm Jeff from Courtroom 5, and this is Who Wrote That Up For You? The show where we follow everyday people battling in civil court without a lawyer. Each episode explores the challenges, victories, and setbacks of self-representation, revealing how some pro se litigants beat the odds while others fall short, and what can be learned from both. If you've ever wondered how far self-represented folks can get in the legal system, or what it takes to keep fighting when it feels like the rules are stacked against you, this episode is for you. Today, we're talking about Alejandro Hernandez and Edith Schneider Hernandez, a couple from El Paso, Texas. No fancy suits, no legal degrees, just 2 people who believed they were mistreated and refused to let that slide. It all started at an estate sale. You know the kind, old treasures, vintage furniture, stuff folks line up early to buy. Alejandro and Edith stopped by, one managed by a company called West Texas Treasures. This was in April 2021, mid-pandemic, and like many businesses, the estate sale required face masks. But Alejandro and Edith told them they had medical conditions that made mask wearing harmful. Now, whether you agree with that or not, under the Americans with Disabilities Act, or ADA, if someone has a disability, a business has to offer reasonable accommodation. So that's what they asked for. But according to the couple, things didn't go smoothly. They say the person running the sale, Linda Walker, told them to make an appointment. But when Edith tried to pin down a time, Walker shouted, "How about I don't know when?" Ouch. And it only got worse. As Edith and Alejandro tried to leave, they say Walker shoved Alejandro into Edith, physically pushed him. Then she reportedly shouted something I doubt she learned in customer service training: "I can discriminate against anyone for any reason." That's not just rude. If it happened the way they say, it could be illegal. Another staffer, Aaron Enriquez, allegedly joined in the chaos and reminded them this was a private business and they could do whatever they wanted. So Alejandro and Edith left. Later, Edith realized her glasses were missing, lost somewhere in the middle of the shouting and shoving. Alejandro called the number on Walker's business card to see if they could retrieve them. But Enriquez answered and, true to form, told them not to come back. Then he hung up. Alejandro and Edith sued. Alejandro and Edith didn't have a lawyer. They filed the lawsuit pro se, on their own, against a business, in federal court. Now imagine that. You've never been to law school. You're reading legal websites at midnight, and you're trying to convince a federal judge that you've got a valid case. The couple claimed the estate sale company violated the ADA, specifically Titles 3 and 5. That means they said the business discriminated against them and retaliated against them for asserting their rights. They also added assault and battery under state law. The defendants, of course, got a lawyer. He filed a motion to dismiss the case, saying Alejandro and Edith didn't present enough facts to support their claims. And here's where things start to feel familiar for a lot of pro se litigants. The judge agreed with the defendants. The district court dismissed their claims, said Alejandro didn't even prove he had a disability, said even if they were disabled, the defendants had a direct threat defense because it was a pandemic. No masks, no protection under the ADA. Then the court tossed out their state law claims too. But here's what the judge didn't do. He didn't let Alejandro and Edith revise their complaint to fix any problems. And they had asked for that chance. So what did they do? Alejandro and Edith appealed the case to the Fifth Circuit Court of Appeals. Still pro se, still on their own. Let's pause here for a second. If you've ever filed something in court and felt like the judge barely read it, if you've ever thought, this isn't fair, I just need a chance to explain, this case is for you, because Alejandro and Edith weren't asking for special treatment. They were asking for a chance, and they got it. The appeals court agreed with them. The court said the district judge was wrong to deny them the opportunity to amend their complaint. It said that pro se litigants should get a chance to fix issues in their first draft, especially if they ask for it. And remember that direct threat defense the district court used? The Fifth Circuit said, "Too early for that." That kind of defense usually comes up after more evidence, not in the early motion to dismiss phase. So just because you don't have a lawyer doesn't mean your case doesn't count. Courts have a duty to hear your claims fairly. That includes letting you fix honest mistakes in your filings. Now let's be clear, the Hernandezes didn't win their entire case. Not yet. What they won was a second chance. The appeals court vacated the dismissal. That means it erased the lower court's ruling. It remanded the case. That means it sent it back down for another look, this time with the expectation that Alejandro and Edith can amend their complaint and tell their story more fully. The battle isn't over, but now they get to fight it on even ground. Here are some takeaways from this case. 1. Persistence pays off. Alejandro and Edith could have stopped after the first dismissal. Many people do, but they chose a different path. They studied the rules, filed an appeal, and won the right to keep their case alive. Their story proves you don't need to be perfect, just persistent. When the court said no, they didn't give up. They pushed back and the system had to pay attention. If they did it, so can you. 2. Judges can make mistakes. It's easy to think that once a judge rules, that's the end of the story, but appellate courts exist for a reason, and when judges forget to follow procedure, like not letting someone amend their complaint, those rulings can be overturned. 3. The ADA still applies, even during a pandemic, even at a private estate sale. If someone claims a disability and asks for accommodation, the law requires more than a shove and a get out. How would you have handled this situation? Add your comments below, and if this episode gave you strength or helped you understand the legal system a little better, share it. Someone you know is fighting in court alone, and they need to know they're not crazy, and they're not alone. This has been Who Wrote That Up For You. Goodbye until next time.
Yeah.